The Supreme Court has declined to put the entire Waqf Amendment Act on hold, noting that no such case has been made out to pass such an order. However, the bench, led by Chief Justice B.R. Gavai, has observed that some provisions may need temporary protection and has stayed certain sections of the Act. Now, the Supreme Court has stayed the practising Muslim clause to donate land to Waqf. Waqf boards can't have more than 3 non-Muslim members out of 11. The Act had provision for at least up to 7 members. And at least 12 out of 22, that has also now been reduced to a single digit. A collector cannot determine the rights to property. It has to be settled in courts. The collector can't decide. Only courts can decide the title of a property. The centre has to form rules to determine if a man is a practising Muslim. So they've stayed it till the time the centre notifies the rules of how it defines a practising Muslim. Till then, any ruling on the same will be arbitrary, is what the court has noted. No third-party rights can be created during proceedings. So the Waqf also cannot give it to a third party. So even if it continues to remain Waqf, despite it being challenged by the centre or being asked for, till it is settled, the Waqf also cannot hand it to a third party. So no third-party rights. No case has been made out to stay the entire Waqf Act. They believe the intent is right, but there have been some riders. Now, while the centre has welcomed the Supreme Court ruling, the opposition has said that stay orders are a major indictment of the Act. Listen.
से पार्लियामेंट ऑफ इंडिया का जो डिसीजन है उसको कायम रखा, लेकिन जजमेंट को स्पिरिट और जो पूरा संपूर्ण ऑर्डर का भाव को मैं कहना चाहता हूँ कि हमारे लिए, देश के लिए बहुत अच्छा जजमेंट आया और डेमोक्रेटिक इंडिया के लिए, पार्लियामेंट्री डेमोक्रेसी के लिए ये जजमेंट बहुत अच्छा संकेत है.
Supreme Court has granted some stay, some relief have been given. And these reliefs are very important so far the Waqf Act is concerned. You see, Waqf dispute why the Act was brought. Act was brought basically for the purpose to seize the power of the Waqf board to decide what are the Waqf properties on which belongs to government.
एक अच्छा फैसला और कुछ पॉइंट्स जिसमें माननीय उच्चतम न्यायालय ने रोक लगाई, स्टे को आगे बढ़ाया, वो बहुत क्लियर है और उससे वक्फ करने वाले लोग, वक्फ की ज़मीनों को सुरक्षित रखने की लड़ाई लड़ने वाले लोग, मुझे लग रहा है कि वो खुश होंगे क्योंकि ये एक अच्छा फैसला है.
Clarified that its directions are interim in nature, issued to safeguard rights until the law's constitutional validity is examined in full at the final hearing. The question now remains, does the order indicate that more tweaks are needed to the Waqf Amendment Act, or is it being defanged for the larger cause to place guardrails and accountability measures? Let's go across to Ishkaran Bhandari, lawyer at Supreme Court, and Tausif Ahmed Khan, a lawyer himself. So two advocates now. Let's I hope you have perused the judgment in detail. Your thoughts. Ishkaran, let's start with you. Yes. Thank you for your patience, gents. Namaste and Jai Hind. Go ahead, Ishkaran.
Yes. See, firstly, the first step was that the petitioners wanted to argue that the entire act is incorrect. It should be stayed. That has clearly been rejected. What has been given, there are certain, you have to leave it and you have to see it on both sides. What has been given to the center, what all has been upheld, and what has been stayed. And stayed also in some of these things is a partial stay. For example, that 5-year practice, if you do not have a practice of 5 years as a Muslim, can you make a waqf? That is still the state government frames the rules for them. For example, you see CA, there are various enactments in which even if passed, unless rules are framed, they cannot be operative on ground. So the rule framing is essential, and that's the part which the court has recognized that without rules it may lead to a certain amount of arbitrariness. So you frame the rules for that. But is that clause, is that section itself to be stayed? That has not been done. When the rules are framed, they may be challenged, they may not be challenged. We will see what happens, but it's a step which has to go forward. The second aspect, that no non-Muslim should be a part of the board, is what has been argued very often. That has clearly not been done. 3 out of 11, 25%, 27%, whatever it may be. Even with respect to the CEO, as far as possible, an endeavor should be made. But it is not that it shall be. So, depending on the state government, they will make an endeavor. If they find the best person, it could be a Muslim, but there is also some amount of discretion left that has to be decided. But what are the important factors in favor of the center that has to be gone into? Because one of the most important things was, and not only in this case, in last 10 years, I believe a new ground has arisen that on one pretext or the other, we will not show documents. We will not show documents if it is about NRC, if it's about illegal immigration. There are people who do not want to show documents if it's about voting rights, whether illegal should be able to vote or not. There are people who argue not show documents if it's about whether we are the owners of property or not. An ordinary person has to show an entire chain of property. If you buy a property, you have to not only show how it was allotted, what is the mother deed, how it was subsequently transferred. So all documents have to be shown, and it has to be duly registered. For example, for immovable property, the law is very clear that you cannot transfer an immovable property without a duly registered deed, be it a gift deed, be it a deed or whatever. But this ground that we will not show and we will say it is by user is what the ground which has led to a lot of complications. And because how do you say what is user, what is not user, and then the person has to fight a very, very stiff battle to prove that. So that the court has said, at least in respect of prospectively, that you will have to register. There has been no stay on that. Then we have to deal with tribal rights. There are certain restrictions on tribal lands. Those restrictions which the Act wants to make stronger, saying that a tribal land should not be parted away in this manner, the court has not stated that. The bar has been kept there. What about ASI monuments? The court has accepted that. So, in totality, it's an interim order. The final order very often can be different. It could be an absolute flip. But as of today, I would say 90 to 95% of the Act has been upheld by the court. And what has been stated, the collector point, yes, it has been stated, it's a clear state. But even in that, you cannot create a third party interest. Even in a litigation between two private parties, if one person is in possession, we call it a stay order, that the person in possession cannot create a third party interest.
Right.
So in this case, who is in possession cannot create a third party interest. So we have to see it that, but to me, the biggest finding is that out of this 90-95% of the Act has been upheld, which was a big threshold to cross because it was said that the entire Act is ultra vires. The second aspect is what has been stated is also some amount of conditionality is there, which the government has some recourses it can take if it satisfies the court once it takes that. And the third aspect, waqf by user, registration, limitation law, ASI monument, all that which was very important has now come in, is not state, is the law of the land.
Yeah, waqf by user being prospective and not retrospective is a critical view there. But when everything is going to be, has to be settled or decided, that means things are going to hang around in courts for a long, long time. Now, is that good or bad? It's going to be in limbo. Tausif, your thoughts?
So you see, the principal protest against this amendment from the entire Muslim community and the liberal community, right-thinking person, was that this is an attempt, this amendment was an attempt by the central government to grab Muslim lands, to grab lands belonging to Waqf. And what was the medium through which government tried to do that? Central government, by bringing this legislation, had this evil design to use collector to dispossess to change the nature of the Waqf land and to dispossess the Waqf board of the land and to take it away and then do whatever it wants through the collector. Now, this is the most crucial attack, most crucial vehicle by which the government had planned to grab the Waqf lands, to grab the Muslim land, to grab the land meant for the charitable purposes, meant for the poor of the society. And the Supreme Court has very clearly, leaving no room for doubt, had striked on this. Now, very clearly, Supreme Court had said there is a stay on that proviso, there is a stay on the subsection of Section 3. And they very categorically stated that no third-party interest can be created in the meantime. It is the tribunal who will decide for all the matters pending before it. The collector can in no way decide who the land belongs to, because, needless to say that it is not only ultra-vires, but it is unheard of. Yet the government proceeded to bring this legislation because government or the BJP party wanted to play this Hindu-Muslim binary, the Hindu-Muslim politics for political reasons. And we all understand that not everyone here, there are, WhatsApp University Chhatra, there are Andhbhakts, I have nothing against them. But yes, there are right-thinking people everywhere in the society. And even the advocates in the Supreme Court who were representing the Waqf side were all non-Muslims, and they all understand what is legality, what is legal. And let me tell you, I was one of the petitioners, and I was present in the Supreme Court the first day. And Tushar Mehta himself, the Solicitor General himself, assured the court, and even the day after, even before the stay order was passed, that in effect they were not going to take any action. The stay order, the formal stay order has come now, but the interim assurance, was already given by the central government that they will not proceed, in accordance with the amendment, just in line with what we see now. The order has been formalized by the Supreme Court, but this assurance was already given by Tushar Mehta himself.
So is Tushar Mehta a Is Tushar Mehta a right-minded person or not?
No, it's with lawyers.
I'm just saying you're welcome to hold your opinion, but don't pass judgment on who is a right-minded person and who is not. That you don't have the right to. You have the right to say what is your thought process. If you're trying to say that people. No, one minute. You have every right, like I said, to have an opinion on the judgment and to interpret the judgment. But who is a right-thinking individual and who is not a right-thinking individual is not for you to pass a judgment on. And if you want to define Andhbhakti, sir, there are many Andhbhaks we can define, who call themselves Maoists but practice Islam, who call themselves Marxists but practice Islam. So what is the bhakti and what is the political ideology can be questioned. So I'm not getting into all of that. So I'm just saying, please don't pass these kind of judgments. You are entitled. You are entitled to your view, but your freedom to have a view stops at my nose and at Ishkaran's nose. Are you trying to say that Ishkaran Bhandari is not a right-minded individual? That's what I'm saying. Yes, Ishkaran. No, I'm just making an observation.
I need 10 seconds.
I'll give you.
I need 10 seconds to rebut what you have said.
Okay, go ahead.
What I said, that the evil design of central government to dispossess Muslims of their Waqf land through use of collector has been completely demolished by the Supreme Court.
You are welcome to say that, and I did not question you there. That is your opinion on the judgment. Please go ahead on that. But beyond that, or whatever suffixes that you added, that's where I raised an objection to. Yes, Ishkaran. Yes, Ishkaran Bhandari.
And then two short points, because a lot is being said about the order today. The learned Solicitor General, of course, is going to argue what's the law, what was in the act. It is only outside you spread misrepresentation, then the court decides the act as passed and you say it's a victory. For example, how was it say CA is going to take away the citizenship of Muslims? We saw in n number of speeches on that. The act never did it. But if the court holds that the act will not take away the citizenship of Muslims, you will come out and say it's a big victory. This is a self-fulfilling argument. They can do that. But the reality is what has been happening. There are two aspects. One, I want to address what the point you raised. Retrospective effect. To my mind, we have to retrospectively examine, but it is to my mind. It is not what the act has been passed right now. To my mind, there has to be a retrospective examination of all properties declared as Waqf by user, whether they had a right to create that user or it is illegal occupation of land, and that if it is an illegal occupation of land has to be corrected in my mind, and I believe we will move towards it. We have to move towards it because the data has come out how from around 2 lakh properties registered as Waqf in 2013, around 18 lakh acres, now it's become 39 lakh acres. That's a human jump. In Delhi itself, the data has come out. I was reading an article and there is enough government records on this, how it has a 10-fold jump. We have a Delhi High Court case going on where time and again, even though the High Court in 80s gave a judgment, successive governments try to denotify the land and say, no, this has to go to Waqf after court judgment in lands which Britishers had recorded as not being Waqf. So we have constant attempts to that. So we have to re-examine that issue because that is, it cannot be a case that certain benefits or illegality via law were allowed to be perpetuated.
Now here is the thing. Has this act in its current sense, even in the interim sense, been defined? Has it been written? Because there are a lot of people who do not even agree with the way the Waqf Amendment Act has been drafted. If it was really to curb the alleged malpractices or misuse of Waqf itself. The court today in its interim judgment has very clearly said Waqf is an Islamic act. It's under the rules of Islam. So a non-Islamic person trying to donate it to Waqf does not make any sense because it's contradictory in its claim. So that observation has also been made despite being argued very heavily in court. So that's also happened. But this is an interim judgment. We'll wait for the final one. I have to move on.